Hello everyone and welcome back to the channel and welcome to the penultimate chapter in our mini-series looking at the criminal justice process. And today we're looking at appeals to sentence, so this is fairly late on in the process. If you haven't watched the previous 8 chapters and you are studying law or just interested in the journey of a criminal case from arrest all the way up to appeals and sentence, I do recommend you go back. And if you do enjoy the content or find it informative, please do like and subscribe. So appeals are all about challenging decisions made in criminal cases. Whether you're a defendant seeking to overturn a conviction or sentence, or the prosecution asking the higher court to correct a legal error. Think of it as a legal ladder. So magistrates or youth courts go up to the Crown Court and then possibly the High Court by something called case stated or judicial review. We'll touch upon that within this video. And for indictable matters, they go to the Court of Appeal, Criminal Division, and in rare cases, all the way up to the highest court of the land, the Supreme Court. So if you're convicted or sentenced in the Magistrates' Court or the Youth Court, you can appeal to the Crown Court. And this is a rehearing de novo, meaning the whole case is heard again. You usually have around about 21 days to lodge your notice. If you are studying the bar course, please refer to the latest syllabus for that year that you're undertaking the exam, just to check if there's any changes. But the Crown Court can confirm the decision, reduce the sentence, or increase it within lawful limits. Bail can also be granted pending appeal. It's effectively a fresh start, but only one level up on the ladder. So I mentioned something about case stated. The case stated procedure deals with errors of law, or where the lower court acted beyond their jurisdiction. So we touched upon the sentencing powers and the powers of the magistrates to try and sentence certain cases, either summary or either way. And where they're in doubt about this, they should be referring on to the Crown Court. But it's not about re-examining the facts. The tribunal literally states the case, writing out what happened and what question of law arises. This is then sent to the King's Bench Division of the High Court, and it's a paper-based process with tight deadlines. Typically, it's around about 21 days to apply. And this route is commonly used by both the defence and prosecution, where a clear point of law is in dispute. So you may have heard about judicial review as well. So judicial review is about supervision, not substitution. So it checks that decisions are lawful, rational, and procedurally fair. And they follow the GCHQ principles. So there was a case a while back which established these principles. I do recommend you go and look into that and read up on that case. But the main principles are illegality, irrationality, and procedural impropriety. It must be brought promptly and within 3 months of the decision. It's normally used where there's no adequate right of appeal. And in criminal litigation, judicial review is fairly rare but vital. For example, challenging a Crown Court decision when they've got no statutory appeal existing. So when appealing a conviction from the Crown Court, you must obtain leave to appeal, usually from a single judge. And the legal test is the conviction is unsafe under Section 2 of the Criminal Appeal Act 1968. Grounds might include misdirection by the judge, admission of unfair evidence or fresh evidence. However, frivolous appeals risk a loss of time order, meaning the time spent waiting won't count towards the sentence. So it's important to only really appeal if there are adequate grounds. And we did touch upon this in the evidence and criminal trial episodes 3, 4, and 5. So I do recommend you go back there. And we talked about the half-time submission, whereby if the prosecution's case is not strong enough to safely convict, it shouldn't be put to the jury. And sometimes where this half-time submission has been rejected and it goes to the jury, there are sometimes grounds for appeal if it was deemed to be incorrect and unsafe for the jury to verdict on that. So once seized of an appeal, the Court of Appeal has wide powers under Section 2 and Section 3 of the 1968 Act. It may quash the conviction, substitute a lesser offence, order a retrial, vary the sentence, or dismiss the appeal. The court's core purpose is to ensure that justice has been done and seen to be done. I'll just go back a little bit. Fresh evidence and the appeal court's discretion. So the court may receive fresh evidence also under Section 23 of the Criminal Appeal Act 1968. Must be capable, credible, admissible and reasonably not adduced at trial. So as you can imagine, now it's a number of years with the backlog of Crown Court cases. Sufficient time for all the evidence to come out. So really there's a high threshold here, and it needs to be reasonably not adduced at trial. Safety remains the key test, so fresh evidence may lead to quashing, retrial or dismissal. So the prosecution can also appeal certain rulings made during a trial under the Criminal Justice Act 2003. For example, a terminating ruling that ends the case early or decision excluding crucial evidence. So these require the Director of Public Prosecution's consent and also a public interest certificate. And it's a delicate balance, ensuring justice without harassing defendants with repeated trials. It's a careful balance. And also, after an acquittal, the Attorney General may refer a point of law to the Court of Appeal under Section 36 of the Criminal Justice Act 1972. And the purpose is educational, to clarify the law for future cases. It's not to overturn the acquittal. So the defendant remains acquitted, but the law is corrected for next time. So double jeopardy, I don't know if you've heard of that term, probably, if you're into your crime dramas. It was once absolute, but since the Criminal Justice Act 2003, a retrial may be ordered for serious offences if there is new and compelling evidence. And again, the Director of Public Prosecutions must consent, and the court must find it in the interests of justice. And it's reserved for cases like murder or rape, where fresh forensic evidence emerges, for example. Now, the Supreme Court is the highest court in the land, and it's above the Court of Appeal Criminal Division. So to reach the Supreme Court, two things are needed. One, a certified point of law or of general public importance, and two, the permission to appeal. That's either from the Court of Appeal or the Supreme Court itself. Only issues of wide significance get through, not just simple errors in individual cases. So let's bring it together with some practicalities. The time limits are fairly strict, so it's typically 21 days from magistrates to Crown Court and 28 days to the Court of Appeal. As I said again, this is effective as of time of recording. I do recommend you refer to your latest syllabus in case there are any changes. Defendants can apply for bail pending appeal, though it's granted only in exceptional cases. If you miss a deadline, you'll need an extension of time with good reason. So for exam and advocacy purposes, really it's just memorizing the core basis of the flow chart. So who is appealing, which court, on what basis, and what remedy is available. So we've got appeal, case stated, or judicial review. Each has its own route, test, and outcome. And always remember the mantra, justice must not only be done, but seen to be done. Okay, so that was just a very, very brief look at appeals, and there is a lot of text to learn. in terms of the actual syllabus. So if you are interested in this area of law, do recommend you do some further reading on that. If you did find this useful, please hit the like and subscribe button and follow more content of UK law explained and also more legal training. And if you do have any questions about appeals or a case you'd like covered, just drop it in the comments below. I do try to read all of them. And that really does complete the journey from arrest all the way up to appeal. We've got one final chapter within the series, and that's chapter 10, youth courts. We've got that as a standalone chapter at the end of the series, just to look at it specifically. And we'll explore how the system treats young offenders differently and why the focus is on rehabilitation rather than punishment. But again, thank you for watching. Hope you do subscribe, like, and tell your colleagues as well. And we do hope to see you on the next episode. It's bye-bye for now. Take care.